I know we have some time. Yeah. So I want to ask you, what do you?
Here we are. See.
Welcome to Queer Politics webinar number 26, where we are delighted to have with us today Ari Waldman, who I will introduce in a second. Thank you for joining us today. I'm sure we'll have a few more people rolling in. Regular announcement, if you are willing and able, we will be delighted to see you. And I know Ari and myself would be delighted to see your faces. So if you're able to and comfortable, please turn on your webcam so we can see an audience. Thank you for sharing that. And just to remind newcomers, we will take approximately half of our hour today with the presentation from Ari, and then we will take questions, comments, discussion on the topic at hand. If you would like to be on the question list, please at any point send me a message in the chat window saying you'd just like to be on the question list. You don't have to tell me what the question or comment is, just that you want to be on the list, and then I can prepare that and curate that list as we move into the second half of the presentation today. So I should introduce Professor Ari Waldman, who is at Northeastern University. Ari is Professor of Law and Computer Science and the Faculty Director of the Center for Law, Innovation and Creativity at that university, in the School of Law and also in the College of Computer Sciences. So Ari is particularly interesting in his scholarship in studying a range of intersectional topics between law, between technology, and between the world that we increasingly live online within. He's done a lot of work on privacy, on online harassment, free speech, and of course the LGBTQ community writ large. Couple of books that I know some of you have used for your work as it intersects with law and politics: Privacy as Trust, Information Privacy for an Information Age, which is from Cambridge in 2018. And then a book that's forthcoming from Cambridge called Inside the Information Industry. Ari is elected to the American Law Institute in 2019. And also, I think germane to us, founded Legally Queer, which is a social media project that works on the intersections of law, equality, and social justice. Actually, Ari, before my time at Princeton, was a visiting faculty member at the School of Public and International Affairs at Princeton, at SPEAR, formerly known as Woodrow Wilson. The name I'm sure we should not speak anymore, and has also been a visiting professor at NYU. So this is a slightly different departure for the Queer Politics webinar, to start thinking about law and the intersections with queer identity. Ari's presentation will be on queer lawyers and queer identity. And I know I'm greatly looking forward to learning much more about this form of the public sphere that some political scientists don't always enter into. So without further ado, let me welcome Ari to present to us today. And please feel free to send me your names if you want to be on the question list anytime during the first half.
Great, thank you, Andy. I really appreciate it. Thank you so much for having me, to not just you, Andy, but everyone. I feel like I've been to quite a few of these, and I always learn so much, partly because I'm a socio-legal scholar. My PhD is in sociology, and I'm a law professor. So I come at questions, many of which you're also asking, but from a very different perspective. So one of the reasons why I wanted to talk about this very, very, very early stage project, really in the early research hypothesis phase, is to get your advice and your perspective on literatures that I might not necessarily automatically think of when I'm thinking about this project. I'm at a point in my work where one research agenda is ending and another one starting to begin. So it's I think, a very generative time, and I really appreciate the opportunity to give a talk that may not be as developed as some of the other presentations, like Phil's, for example, on respectability politics, where he had all of this great data. I don't have a lot of data yet. I'm still at the beginning phase, but hopefully that means you can help quite a bit. So I'm going to share my screen. I just have a few slides. And the slides are really to provide us all with something to look at as opposed to just me, which is kind of boring. Oops, sorry, let me back up here. And great. So as I said, this is a socio-legal project. You know, I'm a lawyer and a sociologist, and I'm interested here as part of other work that I'm doing about the intersection between identity and legal work generally. There's been a lot written in the legal field about discrete areas of queer law and queer impact litigation. Tons of books written about marriage equality. Bill Eskridge, for example, just finished writing a nearly 1,000-word tome on marriage equality litigation, where it's mostly about law, but the book does extensively go into the work of lawyers and the trials on the ground, which is kind of a new thing. Lots of other work on policy work, policy issues, and legal doctrines on marriage equality, and many other topics. What I want to talk about, though, is what I'm interested in is the intersection between the identity of queer lawyers and the work that they're doing to represent or to conduct impact litigation on behalf of the rest of us. So I'm going to start with a big question. The question that I'm asking, my major research question I'm asking is, what is the role of lawyer identity in LGBTQ impact litigation? In particular, to know a little bit about how these cases are developed, there's a difference between, say, the lawyer that does the oral argument at the Supreme Court or at the appellate level and the lawyers who are on the briefs, right? The ones who are doing the real grunt work. There's a difference between who leads the case at the district court level and who might lead the case at the appellate level. And there are lots of other different assignments and allocations of resources and responsibilities that LGBT legal advocacy organizations decide amongst themselves in what I'm calling these movement cases. So there are thousands and thousands of cases from the district all the way up to the Supreme Court and state superior all the way up to state Supreme Court cases that implicate queer legal equality. And it's one of the reasons why I started Legally Queer is to highlight some of these, because lots of people will all know Lawrence v. Texas, but you won't know Troxel and many of these other cases that are really important. So I'm narrowing this project to cases where legal advocacy organizations like Lambda Legal, the ACLU, LGBT Project were involved in. And what I mean by movement cases are those cases where it's not just some random litigator that happens to have an LGBTQ client, but that has some grander impact on the community. So I'm interested in how they allocate responsibilities and who those people are that are given certain types of responsibilities. How do those trends and how does allocating those responsibilities change over time? And how does those allocations of responsibility change given the court that you're arguing in front of? So as a former appellate litigator, as a former young appellate litigator, there were times where I was taken off cases because our case was going to the DC circuit where they wanted someone more superior. Are there similar allocations of resources when we're thinking about LGBTQ impact litigation as well? And so a little roadmap for this short presentation that I'm going to talk about today. Talk a little bit about some of the literature that inspired my interest in this conversation. I'll provide you with one basic example to show kind of a proof of concept of what I'm thinking about, and then talk a little bit about hypotheses and how I'm designing my fieldwork study. And then I'm going to turn it over to you to ask for advice and answer whatever questions I can about the project as it stands. But again, this is a very early stage project that I'm seeking support and advice on. So there has been some work done at the intersection of identity and impact litigation in minority communities. So Kenneth Mack in 2012 wrote a book called Representing the Race, which is a really wonderful book. I recommend people reading if you're interested in civil rights, about how Black civil rights lawyers operated within an institution that was essentially built to maintain white supremacy. So how is it, so then early on, like he wasn't just talking about Thurgood Marshall, for example, but he was talking about on the ground, as well as leading attorneys back from the 20s and 30s and even earlier, and profiled many of them over time, and argued that Black civil rights lawyers performed their identity within legal systems in order to, as part of the process of advancing the cause of civil rights. So it wasn't just winning cases, it was the fact that it was a Black lawyer who was representing the Black community in this space that had traditionally been the space of white people. And it raises interesting questions about the role of identity in a movement for civil rights. So Carlos Ball, who's a professor at Rutgers Camden, he's written several books on litigation about queer family law, as well as marriage equality, both in 2011 and 2014, in which doesn't really talk so much about the identity of people, an entity of lawyers and the roles that they play behind the scenes, but goes into detail about a lot of these cases that are not normally talked about in legal scholarship. And of course, as I mentioned already, Bill Eskridge, one of the leading legal scholars in the LGBTQ space, has just written a tome that just like takes up half of a shelf on some of the marriage equality litigation, which is remarkable, and does some of the same, uses some of the same research methods going into archival material, reading briefs, reading drafts of briefs that aren't actually public, as well as referring to talking about strategy, litigation strategy. So based on having read these books and based on this work and my interest in performance of identity generally, I started to wonder, what is the role of identity in queer politics? So just to give you one example, Bowers v. Hardwick, very famous case for those who aren't aware. This is a 1986 case decided by the Supreme Court that said that state anti-sodomy laws, which criminalized non-vaginal intercourse. Some were focused on the gay community, were constitutional. So it essentially made all gay people presumptive criminals until 2003, when that was overturned. But in 1986, the brief on behalf of Michael Hardwick was written by Larry Tribe, a Harvard law professor who had a thriving appellate litigation practice, along with his student Kathleen Sullivan, who went on to be dean of Stanford Law School, and others. All these people, Larry Tribe, who was the head of this, case, worked with movement lawyers, but he's a straight man who was selected to give the oral argument in this case. As you go forward, there are tons of other, do some research about all the cases that Lambda Legal, the ACLU LGBT Project, and others were involved in. There are, this is just a snapshot of nearly 850 cases in just about 15 years. That means there are thousands over since One Inc. in the 1950s, which was the first Supreme Court case that even had anything to do with explicitly anything to do with queer people. So there are thousands of these cases. And then when you start looking at each of the cases, you look at Westlaw will always tell you who the attorneys were. And they will always make a distinction between who made oral argument and who was on the brief. And think about, so let's take, for example, it's actually not on this slide, but take, for example, how marriage equality litigation evolved and how litigation strategies changed all the way up to the Bostock v. Clayton County decision, which was a Supreme Court decision last year that said that Title VII, which is our workplace non-discrimination law, covers under the umbrella of banning discrimination because of sex, also covers discrimination on the basis of sexual orientation and gender identity, an important formal equality victory for the queer community. in that case, the people who wrote the briefs were a really good representative group. You had trans lawyers, you had queer lawyers of color who worked together from different organizations who gathered plaintiffs, who were one of whom was trans, gathered plaintiffs, did the research, wrote the briefs. At the Supreme Court level, you had a mix of straight white lawyers, white lesbian lawyers who were delivering oral argument. Take a little bit step back, marriage equality litigation, cases like United States v. Windsor, which held the Defense of Marriage Act unconstitutional, as well as Obergefell v. Hodges. You had a mix of straight lawyers and lesbians, as well as white gay men who were delivering argument. On the briefs were a far more diverse group of younger lawyers. These on the briefs involved in there, because as I'm sure you remember, there are a whole ton of marriage equality cases in various different states. So in a lot of these cases, there were a lot of different people involved, and sorry, I was just checking the chat. I thought there was something for me. So there are a lot of different people involved, and when you look at a lot of these briefs, there was always a distinction between who wrote the briefs and who was delivering argument at even the district court level and then the appellate court level. So for example, Gay and Lesbian Advocates and Defenders, an organization, a legal advocacy organization based in Massachusetts, where its longtime litigation director, Mary Bonato. You had a lot of new lawyers who come from various different backgrounds, identified in different ways, who were doing the research and writing the briefs, but none of them were allowed to give oral argument, even though they had written the briefs. And this isn't just a feature of the 1980s or the 1990s, where cases like Bragdon v. Abbott, which was about HIV, which is on the screen here, Romer v. Evans, which was a remarkable case where Colorado voters had essentially taken away the political process from queer people to advocate for employment or other forms of non-discrimination protection. All of those cases were litigated and led by straight people. This isn't unusual. The integration of non-minority lawyers in movement impact litigation for a particular minority community is not unusual. Mack, for example, and other scholars of the Black Civil Rights Movement talk about how it was Thurgood Marshall's strategy to always have a white lawyer as first chair on a lot of these early cases. And they did that for several reasons. There was a strategy that obviously you were Black lawyers focusing on issues important to Black equality, but you had all white jurors. You had all white juries until that was declared unconstitutional. You had mostly white judges, especially before the Carter administration, who was really the first administration to diversify the bench. So there was that, you wanted your lawyers to be similar to, or you wanted the judges and the juries to be able to relate to your lawyers. But there's also this canon, or this important, obviously the one of the most important things about representing a client is you want to win, right? And as many lawyers will tell a client, the goal to win, and we're going to do whatever we need to. I'm going to be a zealous advocate and do whatever we need to and engage whatever strategies we need to in order to win. That strategy, or that push to win, has, I think, resulted in a silencing of certain minority groups within the LGBT community when it comes to their role in a lot of these cases. So it's almost a form of self-censorship, where the queer community, as evidenced by these movement organizations, many of whom situate themselves very much on the left of the scale of American politics, who feel great pressure to to make sure representation is appropriate within their ranks, who then take refuge in the idea of, well, we have to win in order to limit the voices of their more marginalized lawyers. This creates a tension, right? This creates an important tension between the goals of impact litigation, i.e. victory and changing the formal law, and the social importance, the highly valuable and socially important idea of representation. So to parallel one of the arguments, and here's where I'll end and then kind of ask for advice from you all about additional literatures and where else to, what kind of study design, and I'll talk about the study design before that, is to parallel Mack. Mack suggested that Black lawyers operated within white supremacist legal institutions and performed their identities, performed their role as Black lawyers as part of the movement to push the institutions toward formal Black equality. And to the extent that there is a silencing of more marginalized populations within the queer community, I wonder if that's also the case here. Or are we unnecessarily self-censoring ourselves by assuming that the federal and state courts are going to be more susceptible to, or more willing to listen to arguments from at least a straight white man, or a white gay man, or a lesbian, as opposed to many of the trans lawyers, lawyers of color, queer lawyers of color, and non-binary lawyers who are doing a lot of the grunt work in these organizations. So how do I propose to do a little bit more research about this? Again, I'm a socio-legal scholar, so I'm collecting, along with a group of research assistants, we're collecting essentially all of these cases, but we're defining them as movement cases. These are cases where Lambda Legal and other organizations were directly involved. And then we're going to look at the briefs, see who is involved in the briefs, and then I'm going to do some interviews. I have the opportunity already to be embedded in some of these organizations over the next year, and I'm going to like to interview people who were involved in these cases, going all the way back to, Larry Tribe in 1986, and John Davidson, longtime head longtime legal director at Lambda Legal, Mary Bonato at GLAD, and talk to them about these strategies, and also see and be embedded in these organizations and see how these conversations go. And I don't know what I'm going to find. I'm at this point where where hypotheses are still coming. And it also may be just a matter of time and change and social change, that these things are evolving over time. And I wonder if strategies are evolving with them. So with that field work, with that primary source research, and then hopefully be able to review some non-public documents, like within some of these organizations, and to be able to see how cases progress, from one state to the next. You don't always see that in the final briefs that's in the docket. So why I'm here to talk about this with you guys is, I'm not a political scientist, but I'm a social scientist, and I'm interested in making this project as interdisciplinary as it should be. So given your backgrounds, I'm interested in thinking through with you, what kind of questions from your expertise does this project raise? What literatures do you think that I should be reading that, that I might not have given my background? What studies have been done in this context, in the political science or in the legal studies context, that have maybe seen trends or done this empirically, or looked at something related to this to see empirical trends over time? And then any other questions that you might have that I might be able to fill in as I start really in the first stage of this project. So thanks very much.
Fabulous. Thank you, Ari. Let me make a call for questioners. Send me a note in the chat box if you wish to be on the question list. I'm going to be narcissistic and steal the chair's prerogative very quickly for one first question, and then I'm going to call Pippa Cattrall. But something that popped into my mind, Ari, was the question, the variable of the judges themselves. I know you mentioned the level of court, but I remember reading anecdotal stories about perhaps Supreme Court cases, but also lower level cases of judges having some personal relationship to an issue that changed, that actually meant that, well, A, perhaps their ruling changed, but B, perhaps the way the advocates presented was partly conditioned by who they thought the judges were and what they thought the judges thought. And that's actually beyond the judge being LGBTQ. It's like, I remember reading about Rehnquist and the supposition that Rehnquist became more sympathetic to single women's rights and the rights of women bringing up children when his daughter was divorced, and Rehnquist himself started taking care of his granddaughters much more proactively in Washington because his daughter had split up in her relationship. And the argument was that he actually changed in some of his attitudes towards gender issues because of this, and appreciated the dynamics a little differently. And obviously, a lot of political science contact theory says that the more you know queer people, the more you know lesbian and gay, transgender, non-conforming people, then the more likely you are to be empathetic and perhaps shape some of your views about that. So if you suddenly have a family member come out, or if you have a very close friend who comes out or has always been there, perhaps the advocates might look at that judge and say, we need a different strategy. So really, that's just saying, to what extent do you think you can get some purchase on the variable that are the judges themselves?
Yeah, that's a great question. And so contact theory is definitely at work here. That Rehnquist story is really good. There's also the similar kind of the opposite, Lewis Powell's story about how, I've never met a gay person. And then of course, a lot of his clerks happen to have been gay, but of course not out. And that may have changed his vote in, it changed his vote in Bowers. But yeah, so that is something that I think really can only be teased out in interviews. So there's qualitative research, and ethnographic research sometimes gets a little bit of a bad rap, that but there's no other way to kind of get that story about how people identified what kind of arguments they were going to make based on the judges, unless you actually talk to them, because those kind of things aren't really public. So that's definitely something. And now what I'm starting to do now before I start my interviews is to kind of create a little bit of a semi-structured script of the kinds of questions that I want to ask. And this is really helpful because that highlights, what kinds of questions, or what are the factors that are actually involved in making these strategic decisions. It's not only that, we have a very white bench, so white people get to do oral arguments, but are these other things as well, and not just. I think you're right. It's not just the identity of judges. Like Vaughn Walker is openly gay, or to a certain extent, it was an open secret that he was gay. But did that really change the actual arguments that they made in that trial? But yeah, that's great. Contact theory is going to, I think, play a role here. The Rehnquist story, I actually didn't know about that, but I think there are plenty of examples like that.
Yeah, and I just throw in one interviewing technique, which you may know about, that I found invaluable to me when I was doing interviews for my book, The Children of Harvey Milk. After the first few interviews, I realized I should never turn the recording equipment off when I said, thank you, we're done. When you close that conversation, you say, thank you, this was amazing. Then the next 10 minutes, they give you the most amazing, authentic, honest stuff. Now, I always went back and I said, can I use that? And 99% of the time they said, yes, you can use that, that's fine. But the level of shoulders dropping, relaxation after the end of the interview, suddenly they say, oh, let me tell you about this story. Yeah. Never turn the interview thing off, never turn
That's so true. I actually found that now because I'm writing a paper now based on interviews of lawyers who do work, who are victims' rights lawyers, who represent victims of cybersexual violence, many of whom are queer and women. And that happens so there's a small group of lawyers that do it. It happened in about 3/4 of the interview. So true, so true.
Let me call on Pippa for the next question.
Thank you very much. Yeah, I really enjoyed that. Thank you very much, Harry. And it provoked so many thoughts. I mean, one of my relatives, as it were, is Professor of Queer Legal Studies here in England at one of our universities, and specialises in looking at the legalities around barebacking and issues like that, which is one of the themes that you haven't touched on in your talk about what kinds of things you're looking at, because so much of what you concentrated on was about civil rights, I suppose, rather than the actual way in which the state polices sexual behaviour. And it might be worth thinking about how the state gets involved in policing those kinds of issues as well. And that involves him in, if you like, paralegal forms of advocacy, like going and presenting to Parliament, or in your instance, going and presenting to congressional committees or whatever. I'm glad Andy asked about judges, because I noticed you didn't seem to mention that in your presentation. So it's good that that's been raised. But the thing I really wanted to raise was the point about differentiation within the what I prefer to call the LGBTQ spectrum or whatever, because I think talking about it as a community is really problematic. I mean, you were in your presentation flagging up, well, this case had trans lawyers involved, this was a white lesbian woman, etc. And of course, there are people in this room who can talk much more knowledgeably than I can about the way in which income differentials in the US impact upon access to law. But it seems to me that if you're looking at people who are trans or gender non-conforming, then all the evidence suggests they probably have less access to law than straight acting gay couples. So I wonder if there's a power dynamic that you also need to explore when looking at this subject.
Yeah, these are great questions, and absolutely this presentation was necessarily abbreviated, but this isn't just I'm not just looking at just civil rights cases, but policing of sex, policing of the body. You know, that in the United States in the 1950s, well into the 1960s, the police raids on bars and those kind of things. All of those were, you're not talking about Supreme Court cases, but we're talking about using the institutions of law. So all of those are relevant too. So that's absolutely right. Really good suggestion about, we're not just talking about court cases. I mean, I could, if I wanted to, limit this story to just litigation, but I'm not sure. Your point about presenting to Parliament or presenting to Congress and that kind of front-facing work would raise some of the same issues. So I don't see the reason why I artificially limited it to just court cases. So that's a really good suggestion. And the final point you raise about other forms of differentials, and I do want to hear from other people in the group, made me think about some work that I'm much more familiar with in my law and technology field, is about whom do we research? Like actor network theory suggests that we follow the people in the room, but when you follow the people in the room, you're necessarily not following the people who, because of structural barriers, are not in the room, right? So you can't research the people if all you're doing is going inside the room and all you're doing is focusing on them, and then you're missing the people who have been barred from that room. So that I think that's a matter of sensitive study design, and the fact that it's not just a matter of interviewing lawyers at Lambda Legal, but it's also a matter of interviewing people who are still engaged in quote unquote movement cases, but are doing so from outside these kind of rarefied walls of of organizations that may be, again, they may be on the left of the spectrum, but still are gatekeepers, right? There are still structural issues that keep certain people out of those jobs. So that's an excellent point, and I think that's a matter of study. It's certainly something that I'm concerned about and want to include, but I think it's a matter of study design. A little bit harder to get, but that's part of the work. That's part of the fun of this. So thank you very much.
Okay, I wanted to call on somebody who's been an expert witness and worked heavily in a lot of these cases. So let me ask Ken Sherrill to talk about his experiences.
Thanks, Andy. Ira, good to see you. It's been too long.
You too, Ken.
I'm going to take advantage of being the oldest person in the room and talk about old stuff. Also, I think some of this we ought to put off to having a conversation over lunch. The old piece of work in sociology and political science that I suggest that you look at is McKell's political parties, and in particular, the iron law of oligarchy.
Mm-hmm.
And the reason I suggest this is a book that I'll never write, but I invite all of you to write, which is on the institutionalization of the movement, how we went
Mm-hmm.
from being a mass movement to structured pressure groups.
Mm.
And in the early days, or I should say that I was the expert witness who was on the stand for the longest time in Evans, in the Evans case.
Mm-hmm.
And going back to the trial, but all the way through the arguments of the Supreme Court, there were intense, bitter arguments between the local people who brought the case and Lambda and to some degree ACLU,
Mm-hmm.
culminating in a demand by Lambda that Clip, the Colorado Legal Initiative Project, fire its lawyer, replace her with our friend Lawrence Tribe, stop making the argument about being denied the rights of citizenship with access to the political process, and argue protected class and argue strict scrutiny. As one of the lawyers on the board of Clip said to me that after the oral argument, he said, "I represent clients in cases involving millions of dollars. What makes these assholes think that I won't be as vigilant in protecting my own rights?" And yeah, it turns out that we won, that they won, and they won by fighting off the national organization. These tensions went on for quite a while. They, in a way, involved a dispute between identity and ideology. And I think that that's something you might want to look at too. Let me hold off on the rest and try to compel you to have lunch when you're next to New York.
Absolutely. Yeah. Hopefully after this pandemic, but that's the exact kind of story that I'm looking for. And those kind of things haven't really been reported or told extensively in the scholarly literature. So it's clear that Ken Sherrill is going to be a central interviewee for this project. So hopefully we can actually have dinner soon.
Or anybody else the transcript of the orals. Not the orals of the trial testimony.
Yeah, that would be great. Excellent. Yeah, this also involves oral, getting transcript of trial testimony. I don't know if anyone has ever done that, but you would think that in 2021, that would be just super easy. You go on a Westlaw and click a button, but they actually make it really hard still to get transcripts from trials. And I think it's another gatekeeping that the legal profession is engaged in.
All right, I've got ours.
Great, thanks.
Great. Let me call on Phil Jones.
Thank you so much, Alex.
Oh, sorry, Phil. I don't know. We can't, I mean, I can't hear. Can anyone else hear Phil?
No, we're not hearing him well.
Hey, Andy, can you hear me now?
Yeah, we can hear you good.
Okay, I'm so sorry, guys. I don't know, like I have no luck here. So anyway, I was saying that this is a really cool project. I really appreciated the talk. I have one suggestion of work that you probably know, but since nobody's mentioned it, Ellen Anderson at Vermont.
Yeah.
So her work on like legal opportunity structures, I think, is going to be really important here, given the strategic nature of the movement. And then I had a question about case selection or research design, which is, so as you go like up the court system towards the Supreme Court, presumably resources increase, right? Professional groups are more likely to get involved, and the like pool of people who could be involved in the case becomes relatively more privileged, right? Like you're more likely to have like wealthy white cis men involved the further up you go. And so I guess I'm curious, are you looking at Supreme Court cases and working backwards to see where they started out? Or are you starting out at like, I guess, district level and then working upwards? Because that might affect, right, the people who are in the room and how strategic these groups are being.
Yeah, so I made the choice explicitly to start at the bottom. So specifically to avoid that problem, the example I gave in the talk was just because I think a lot of us knew Bowers and Lawrence and marriage equality, right? So it's just sometimes that's like kind of an obvious, almost like proof of concept. But you're right. I mean, the practicing bar at the Supreme Court, although pretty much most lawyers who have practiced for like 3 or 5 years can be admitted to the Supreme Court bar, but the practicing bar at the Supreme Court is overwhelmingly male and overwhelmingly straight. Right. So, so I explicitly started at the bottom, but as I mentioned, there are thousands of cases, and this is a multi-year project. It's not like it's impossible to go through those thousands of cases, but to put a frame on those cases, so far I've thought about 3 kind of limiting factors. And I'm not sure that these 3 limiting factors are the right ones. Like I may totally change, right? That's why this is totally at an early stage. So one is what I'm calling these movement cases, because there are a ton of like criminal cases about, child molestation or, those kind of things that are important, right? When you're dealing with those kind of, as Pippa was talking about, the policing of sex, but they didn't necessarily have a ton of precedential impact on the community. And they also may not have involved even the outsider organizations, the outsider lawyers. So that was one limitation. Another limitation that I was putting on it was that it had to have some effect, right? There had to be some, it wasn't just like a case about this particular person and then that the story was over. It had to have some effect on the community. And that's a little bit of a fuzzier metric, but relatively easy for a lawyer to quantify because cases that have effect are cited, right? Cases that are, and that's it's not perfect, but it's actually, that'd be easy for me to qualify and also quantify and also do kind of a quantitative analysis of that. And then the third factor that I was thinking of was that so impact, movement, and the third one is just escaping me. This wasn't a limiting factor, but good and bad. Right, not just not just cases that ended the way we wanted to, but cases that also ended the other way. So I'm not positive that those are the only limiting factors I put to the data, but I may be put in a position where the lack of resources, like the inability to talk to lawyers or the inability to access primary source documents, would force me to take away some cases just because they may be then outliers. But hopefully I won't get to that. get to that point. But I can imagine that that would be a story. But I'm open to other ways of limiting or additional questions about the study design. Thank
Great.
you for that question.
Yeah, thank you. That's, yeah, it's smart. Thank you.
Great. Let me make another call for questioners. We're going to have about another 10 minutes left. So if you'd like to ask a question or make a suggestion to Ari, please send me a chat message. Next up, I have Jack, who seems to be, Jack Geese King, who seems to be wandering through the streets of somewhere, which is very impressive.
Yeah, the dog calling in. I was spending my beautiful spring day with all of you. Thank you so much for that fantastic talk, Scott. Thank you so much. I learned so much. I was thinking twofold about things that might show up in the data. One is how gender nonconformity might play out, you know, among the lawyers or not, and especially because thinking about Chris, I don't know how to spell. I don't Chris Strangio. Strangio, yes.
Yeah.
Just like following their work and really becoming quite a social media presence, and, you know, Instagramming live feeds at the end of their day about how cases unfolded. And I just think that I'm just watching that. It's a new way of experiencing law to me. And also about geography. So what's rural versus urban? Where does the case come from? Where is it playing out? And you know how you're playing in Alabama versus New York, of course, is so different. I know you know that, but I was wondering if there are patterns that if you've seen any. And those are the two things I'm really interested in. Thanks again for a great talk. I'm really excited to read all this.
Thank you so much, Jack. So I really appreciate that. So with respect to gender nonconformity, this is something that I've actually spoken to a couple of friends and colleagues, social scientists, as well as lawyers who identify as gender nonconforming. And I've asked them, you know, what's an appropriate way to go about this? And one option is to, you know, ask all interviewees to self-identify, and then simply apply what interviewees say to, you know, to the analysis. Now, that it's not possible to interview every single person who's, you know, listed on the cases, but a simple phone call, you know, talking about cases and letting them know what's involved, you know, those kind of things may be really doable. But for the quote unquote heroes, whoever end up being the central protagonists of the story, it's relatively easy, I think, to have people self-identify, but it requires us, and this is, I think, a study design problem, not a problem, but I think important for study design generally, is that it's no longer appropriate for us to think about, to add, you know, gender metrics, gender independent variables to a study that are even just like 1, 2, or 3 different options, right? So and I always, you know, kind of push back on this when I'm at conferences, but given that we're talking about qualitative research here, then I think that's a really easy thing to integrate. The geography thing, I have to admit, I didn't consider that. But I think you're absolutely right that there may be different stories and different strategies or different concerns that would come up when you're dealing with state cases, like when you're dealing with a case in Iowa versus when you're dealing with a case like Bracci in New York. Despite the fact that Iowa Supreme Court was kind of far ahead of its time, but you're just dealing with different contexts, you know, different families, different communities, and your relationship with a lawyer in a small community is just very different than if you're a citizen of New York City and you need a lawyer to go for impact litigation. So, you know, how did Edie Windsor didn't come to Robbie Kaplan the same way that that Iowa plaintiffs, residents of Iowa on presumptive criminality for HIV disclosure cases and so forth, they come to their lawyers in just a very different way. So that's a really important factor to consider. Thank you.
Yeah, thanks. I was just, you know, Gavin Grimm sitting next to Chris Strangio is such a wild juxtaposition of rural and like this cosmopolitanism. So thanks again. It was a great
really
talk.
Cool. Thank you.
All right, let me take a question from Phil Ayoub.
Hi, Ari. Thank you so much for this talk. It's a really great study, and I'm really excited to see how it comes out. I have a comparative question, and it's not suggesting that you should add a comparative case to this work, which is, you know, will be fantastic on its own. But I was just wondering, from a couple personal reflections, and I don't know the answer to this, but I feel, since I work mainly on European countries, I feel like there's there's this legal epistemic community of scholars and lawyers who are really involved in the movement and also involved in cases. And I'm wondering if there's a difference. Anna van der Vleuten has written about the European Court of Human Rights, for example, being more of an activist court on issues like this, going back some decades. And I'm wondering if that creates a different kind of a opportunity for queer people to be represented there. And I really don't know, because this is not what I study, but there's folks like Kees Waldick or Robert Wintemute who would know, or Anna van der Vleuten, who would probably be able to say something about this. And that might be an interesting, factor for the conclusion, or something to kind of think about. Do these same dynamics, is there something American going on there as well? Or is it something universal in terms of how identity and plays out in the courts for queer communities?
What a fantastic suggestion. I didn't consider that either. But I do have to admit, I didn't get the names. If you wouldn't mind, could you just type them into the chat so I can just write those down? But that's a really, thank you. This is a really good idea. Whether this is just an American problem, there are tons of just American problems, obviously, or even if it's not just an American problem, but maybe a problem of the nature of our court system, that there's something about that the European Court of Human Rights allows for greater opportunity for maybe more marginalized groups to have a voice. We don't have those kind of things in the United States, but there also might be the case that, well, those voices are also marginalized in the EU system outside of Strasbourg. So that's a really good focus. So for people you suggest I reach out to, because the pronunciations of the names I just couldn't quite reach, but I appreciate that suggestion.
Okay, let me follow up with one other small question, and then if anybody else wants to jump in with the last question after me, then please do. It came to my mind that an area that might be elicited from interviews, but is probably pretty tough to find, is this question about the choice of advocates because they happen to be queer, but they're in the closet. So I wonder, historically, we've seen advocates and activists and others inside organizations making a difference, but they're in the closet. They're closeted gay men or closeted lesbian women or closeted trans people. And if you go back 20, 30, 40 years, I think there was a lot of influence from people within institutions who were in the closet, or a glass closet, as it were. And so I wonder to what extent you can gain some purchase of that, in the sense that the advocate, the person who is presented, is perhaps a white cisgendered man, and people presume he's heteronormatively straight, but he's really not. And the petitioners know that. And there's a dynamic there which is a little different.
Yeah, so this was a real thing earlier on, like in the 70s and 80s, when it could be career suicide to come out as a gay lawyer, right, as a queer lawyer. So you had people who were actually gay, and they joined Art Leonard's LGBT Bar Association of New York that he started a long time ago. And but so they were out in that context, but not out at their firms, and not and also kept up heteronormative performances. This kind of goes, it's sort of related to, I think it's Kelsey's question in the chat about how do you determine that the attorney making the oral argument is straight? Well, I think this goes a little bit back to what I was saying earlier. People who are interviewing, people I interview, I'm going to let them self-identify. I'm not going to make any presumptions. But you're right, Andy, to suggest that there are other reasons, and there are complicating factors as to these choices. Like an organization could be making a choice to give oral argument or give a plum position to an attorney who is not out publicly, but actually is gay, and that's progress. I mean, that's a form of representation, and that's hard to get just from primary sources, which means that the only way that something like that could come out is with people telling their story. And something like that, Eric Cervini tells similar stories, but in the activist context, not in the legal context. So I imagine that something similar may come through in the interviews. That's a really good point, though.
Fabulous. Thank you. Okay, so this has been a really fascinating conversation, and thank you so much, Ari, for presenting the genesis of this work to us. I think it's going to say a lot about network theory. It's going to say a lot about human contact theory and that intersection of law and politics. So I know many of us will be very excited to see the eventual product that comes out of this. So please.
Thank you so much. I really appreciate the opportunity to talk with you, and I really appreciate this advice. I know it's weird sometimes to hear very early stage talks without a lot of data to present. So I'm really grateful for for everyone's suggestions and questions.
No, it's fabulous, and this has been really good. I should let everybody know that next week we have another entirely new and somewhat different and exciting topic. My pronunciation is going to be horrible until I learn how to do this properly, but Thiago Kochi is presenting to us from Brazil next week on the Brazilian transgender movement, which I know is going to be a fascinating talk as well. So next Thursday, Eastern Standard Time at noon. I should remind you, if you're in Europe or if you're in the United Kingdom, I think there's only going to be a 4-hour difference next week instead of a 5-hour difference. So just double check that because of the weirdness with time changes. At least we aren't in one of those 2 counties in Indiana, which seem to be on their own separate universe. So anyway, noon next Thursday for the Brazilian trans movement, probably 4 o'clock in the United Kingdom. And thank you all for joining us today. Thank you again, Ari, and keep well and keep safe. And we will all see each other soon.
Thank you.